Okay, sir. Welcome back everyone for the second session of the Lexidem Masterclass. In this session, we'll be covering international commercial arbitration. For this session, we have with us Tejas Karia sir, partner, head arbitration, Shardul, Amarchand and Mangaldas. Tejas sir has a very wide experience in handling international and domestic commercial arbitrations across sectors involving disputes relating to oil and gas, shareholders agreements, joint ventures, construction and infrastructure, insurance, real estate, and private equity. Sir has represented multinational and Indian corporations in ad hoc and institutional arbitrations involving major arbitration institutions such as the LCIA, the ICC, the ICA, the ICADR, the RSA, the ICDR, and the SIAC, seated in India, Paris, London, and Singapore. For any queries, please drop your questions in the comment box, and the questions will be taken up by the speaker at the end of each session. Thank you, sir, for joining us today. Over to you, sir.
Thank you for inviting. I hope you can hear me well and also see my screen.
Yes, sir.
Okay. So good afternoon, everyone. Today's topic for me is international commercial arbitration. And we have some subtopics just to be focused because this topic itself is quite wide. You have heard about the introduction, the concept and definition and principles involved in arbitration. I will be dealing with the international arbitration with focus of the seat of arbitration and what are the issues we face while determining the seat versus venue. Then we will move on to the procedural challenges. What are the requirements for a preliminary meetings and deciding the procedure? Bifurcation of the procedure between the quantum and liability. Many times it becomes very useful to have the bifurcation so that you don't put on unnecessary time and effort and cost in deciding the issues which may become redundant after deciding the first issue with regard to the liability. Document production again is a big challenge in international commercial arbitrations. Parties come from different jurisdictions. They have the different set of rules to applying to their own jurisdiction. And when they come to international arbitration, we follow a certain standards which we will discuss. Concept of emergency arbitration, again, it's a topic in itself, but we will discuss that briefly. And how the emergency arbitration has evolved over a period of time and what is the effect of having the enforceability of the emergency arbitration awards. Enforcement of international awards, foreign awards, we will discuss. And lastly, we have all know that we have emerged from a long pandemic of COVID of 2 years and how the international arbitration has coped up with that and evolved through the COVID-19, we will discuss at the end. To begin with, the concept of seat versus venue. The seat is a juridical concept where it has to be a mandatory requirement under any arbitration. Either the parties agree the seat or if in failure of the parties, then you have the arbitral tribunal agreeing on the seat, or the court at the relevant point of time will have to agree on the seat of arbitration. Arbitration clause must clearly specify the seat to avoid any controversy because all these case laws which we will just discuss can be avoided if you simply put the seat of arbitration in the arbitration agreement itself so that there is no ambiguity or need for any interpretation by any of the court or the arbitral tribunal. As compared to seat, many times we get confused with the concept of venue. Venue is not the seat. Venue is a juridical is a geographical concept, and the seat is a juridical concept where venue can be anywhere in the world. It can be virtual also, where parties may sit from different locations and you have online hearings. So therefore, venue is flexible. It can be decided as per the convenience of the parties and the arbitrator. Whereas the seat has a lot of consequences. It gives a supervisory jurisdiction to the court at the seat. So it depends on what is the seat of the arbitration, and the court will have supervisory jurisdiction. Seat is also sometimes interchangeably referred as a place of arbitration. In our Indian Arbitration Act, we don't have the word seat. We have the place of arbitration, which is equivalent to the seat. Seat is mandatory, whereas venue is discretionary. If we talk about most preferred seat in international commercial arbitration, last year, Queen Mary and Whiten case had conducted a survey of international commercial arbitrations. And we have seen that London and Singapore had emerged as one of the most preferred seat of arbitration, followed by Paris, Geneva, New York, and Beijing. The idea is that how the parties see, because the seat has also a concept of neutrality, is that nobody wants to submit to each other's jurisdiction, and they want to go to the neutral seat, which can has as an ecosystem in terms of providing the legal support of the lawyers, arbitrators, and also logistical supports, and having good institutions. So if you see, London is evolved as a seat because of LCIA being a prominent arbitral institutions. Paris because ICC is located, headquartered in Paris. Hong Kong because there is an HKIAC and ICC regional office also in Hong Kong. Singapore because you have Singapore International Arbitration Center. So arbitral institutions also play an important role in promoting the seat in addition to the court system, because in India, we have to evolve to have India as the most preferred seat for international commercial arbitration. We have amended our law in last 7 years and tried to bring India at par at the other jurisdictions, but we have a lot to achieve to bring any of Indian city as part of this survey. So what all we have done? So in 2015, we have reduced the intervention of the court in section 9 and 34. 9, once the tribunal is appointed, the court will refer the matter to the arbitral tribunal for determining interim relief. The language of section 9, which provides for interim measures before the arbitration, and section 17, which provides the interim measures before the arbitral tribunal, once the tribunal is constituted, have been made identical, so that the court are not overburdened and the arbitrators can decide it. We will also discuss the concept of emergency arbitration, which has helped to reduce the burdens on the court. Section 34 provides for challenging the awards, and we have now introduced the concept of public policy. By way of explanation, we have defined the public policy, and that has reduced again intervention in setting aside of the award. Fast track procedure has been introduced in section 29B, where without oral hearing or oral evidence, the written, on the basis of the written submissions, the tribunal can decide and pass the award within 6 months. This is very popular in small amount dispute. Ease of enforceability. There is no automatic stay while the award is challenged. There has to be a specific application for filing of the stay of the enforcement of the award. And a change in definition of court. Earlier, all the matters, including the international commercial arbitration and the foreign awards, were getting going before the district court. Now we have changed it to the High Court, irrespective of if the High Court has the original jurisdiction or not. In 2019, we have now introduced the amendment to have the appointment done by the designated arbitral institutions. It is not yet notified, but it is likely that within few months we will see this amendments to be notified by the government. Arbitration Council of India is in process of being set up. Again, it has been introduced in 2019 amendments and yet to be notified. It will grade the arbitral institutions and accredit the arbitrators. In 2019, we have also added the immunity of the arbitrators, confidentiality, and also made the 2015 amendments to applicable to the pending cases by way of a judgment of HCC versus Union of India. Earlier, the time limit under section 29A, which was 12 months from the constitution of the tribunal, has been changed to 12 months from the completion of the pleadings, which will bring it to overall 6 months for completion of pleadings and 12 months, and the parties can extend up to 6 months. before going to court for an extension. So in all, it can be extended up to 18 months from the completion of pleadings, and in total it will be 24 months. In 2021 amendment, again, we have omitted Schedule 8, which provided the qualification of the arbitrator. One of the criticism was that it says, it mentioned that the arbitrators have to be qualified lawyers in India, whereas it prohibited foreign qualified arbitrators to bring in neutrality. That has been omitted now. India can have foreign qualified arbitrators, also foreign arbitrators, where the seat of arbitration is India. Because the whole idea is to promote India as the hub of international commercial arbitration. And these amendments have helped India to solidify that position. Now, what are the pros and cons for India as a seat? We have award within 12 months. Enforcement is become easier. Challenges, interference has reduced. But as compared to other jurisdictions, we still have to achieve a lot in terms of the judicial intervention. Every month, we have new cases interpreting the Arbitration Act or deciding new positions. There is no time limit for execution of decrees. Once we have been successful in India, the execution of award takes very long time. And also between two Indian parties in a domestic arbitration, patent illegality is an additional ground to challenge the award, which is not available in other jurisdictions. So these are the pros and cons of having seat of arbitration as India. Government of India versus Vedanta decision of Supreme Court decided certain important aspect about the seat. It said that the curial law of the arbitration is determined by the seat of arbitration. So, for example, you have the India seated arbitration. Part 1 of Arbitration Act will become applicable. If you have a Singapore seated arbitration, International Arbitration Act of Singapore will become arbitration just merely by selecting the seat. You may have the governing law of the contract as English law. Both parties may be one Indian and one from US. And you have the seat of arbitration Singapore. The Singapore Arbitration Act, which is a curial law, will be applicable. That is called Lex Arbitri. And the curial law basically governs the procedure of the arbitration, the commencement of the arbitration, the appointment, the challenge, grant of provisional measures, collection of evidence, hearing, and challenging the award. So this is very important law. So you have to carefully select the seat, because the moment you select the seat, you are also selecting the law which will be applicable to that seat. And the court at that particular seat will have the supervisory jurisdiction for grant of interim relief, challenge of award, ensuring the evidence, and also to some extent the enforcement of awards. The court of the seat of arbitration exercise supervisory primary jurisdiction over the arbitral proceedings. Now, this dispute between seat and venue has been continuing for quite some time. In IMEX Corporation, the Supreme Court decided the seat on the basis of the party's decision to select ICC rule and also conduct the arbitration in London. So there was no seat, but what it mentioned is that the arbitration will be conducted in London, and there were ICC rules. So the court came to conclusion that the Bombay High Court will not have jurisdiction to hear 34. It will be the London court will have the jurisdiction, because the seat of arbitration was London. In Roger Shashwa, again, the similar principle was adopted. There was an Indian law governing the contract. Venue was London, and that's where the ICC rules plus London was treated as equivalent to the seat. So the Shashwa principle, as we call it, venue plus supranational set of rules will be treated as seat, and the London was treated as a seat. Hardy took a slightly different view. In this case, three-judge bench of Supreme Court decided that merely selecting a rule of an institutional which is providing services across the globe, the International Arbitral Institution, will not be sufficient. So Kuala Lumpur was the venue, and the parties had selected ancestral rules. The court said, no, it will be the Delhi which will be the seat. This is only one case which has departed from the larger Shashwa principle. The subsequent decisions of Supreme Court has confirmed Shashwa principles, which says that the venue can become the seat if there is no contrary intention of the parties. In Brahmani River, it was a domestic arbitration. The venue was Bhubaneswar and seat was absent. Supreme Court held that the venue will become the seat because parties did not indicate any other seat in addition to Bhubaneswar. In BGS Soma, the three-judge bench of the Supreme Court decided that the arbitration agreement provided the arbitration to be held at New Delhi or Faridabad under the UNCITRAL rules, and Supreme Court, following Shashwa principle, said that any choice of venue in the absence of any contrary indicia would be interpreted as designating a seat. In Mangaldas 2 impacts against three-judge bench of the Supreme Court, it was the arbitration was seated in Hong Kong. Supreme Court held that mere expression of place of arbitration cannot be the basis to determine the seat of arbitration. In the intention of the parties as to the seat would be determined from the other clauses of the agreement and conduct of the parties. So you have to see the surrounding circumstances and then come to the conclusion if the Hong Kong was the natural choice between the parties from the conduct and the nature of the agreement, then the court will determine that as the seat of arbitration. In Inox versus Jayesh Electricals in 2021, the parties by agreement changed the venue of arbitration from Jaipur to Ahmedabad. The court came to conclusion that it was not a shifting of venue but shifting of seat, because it was an agreement by way of an agreement, express agreement between the parties, and therefore the court at Rajasthan will not have jurisdiction. It only the court at Ahmedabad will have the exclusive jurisdiction, because if the venue is shifted, it is basically the seat which is shifted from Jaipur to Ahmedabad. In BSR versus SP Singla, the Supreme Court held that the seat fixed by the arbitrator could not be changed unless the parties mutually agree on a different location. So there has to be a mutual agreement, because the seat is a juridical concept and shifting would lead to unnecessary confusion and litigation. There is also not a case that with respect to venue of the arbitration, it can be shifted easily, but the seat has to be shifted by consent of both the parties or all the parties to the arbitration agreement. Just merely shifting the venue from one place to other will not amount to shifting of the seat. Even if you are having virtual hearing or online hearing, the seat will remain constant irrespective of the location of the parties joining the arbitration hearing. In PASL Wind versus GE Power, the Supreme Court settled the controversy with regard to two Indian parties having seat outside India. Court concluded that there is no prohibition under the Arbitration Act, and the party autonomy would allow the parties to select seat outside India, so long as, of course, the governing law of the main contract, the substantive law, is not ousted, or the Indian law is governing the contract, because two Indian parties cannot contract out of Indian law. Court also said that the Section 9 petition would be maintainable irrespective of the seat of arbitration being outside India, unless it is expressly excluded by the parties. So this is the landmark case where the court has said that two Indian parties can have seat outside India. In Dholi's Fintechs, again, recently both parties were Indian. The relevant bylaws of the Cotton Association provided that the governing law of the contract was to be English law. The court said that the two Indian parties cannot choose a foreign law. They relied upon Reliance Industry and Central Trade, saying that if the governing law of the contract has to be Indian, unless there is some foreign element is present. In this case, if there was no foreign element, the parties cannot contract out of Indian law. Now, let us come to the procedural challenges. The procedural challenges which we face in terms of the preliminary meetings and deciding the procedure. Preliminary meetings or the case management hearings, as we call in some arbitral institutions, are very, very important for any arbitration proceedings, because it lays down the complete timeline of the arbitration proceedings. In most of the international commercial arbitration, on day one, we know when will be the final hearing. And then we work backwards to give all the stages of arbitration in procedural order number 1. PO1 is a norm, and it is usually decided in every arbitration. In some of the arbitral institutions like ICC, we have terms of reference. In ad hoc arbitrations, we have the procedural order. We can have multiple procedural order, but the first procedural order usually deals with the name of the parties, their representatives, appointment of an arbitrators, conflict of interest of the arbitral tribunal, that they don't have any conflict, they are independent and impartial. Issues on the case administrations like fees, expenses of the tribunal, procedural rules. If the parties have selected any rules, then they would be mentioned in this procedural order. Language, place of arbitration, etc. The PO1 also fixes the timeline for the submissions of the pleadings and evidence and provides the rules to be followed by the counsels in written and oral pleadings. So there is no standard template for PO1, but these are the usual items which are discussed. The best way is to send the draft to both the parties in advance of the first hearing, and the parties can agree as much as possible. And then if they have any comments, they can make to the draft of the procedural order number 1, and then at the hearing parties can discuss and the tribunal can pass the procedural order. Now, what are the important considerations to be kept in mind while passing the PO1? This gives you the checklist for PO1. First is to express disclosure that there is no conflict. The arbitral tribunal should disclose at the first instance itself that there is no conflict of interest. The second and most important is the procedural timetable. So who will file pleading first, the sequence of pleading, the sequence of exchange of the affidavit of evidence or the witness statements, and also the final hearing is provided. If the parties are not sure about the date, it should be mentioned, but then in the column of date, you can write to be confirmed or TBC when the dates are not fixed. Guideline for filing of pleadings again is very helpful for the parties so that the pleadings are filed in a uniform form. If you have a footnote, how the exhibits will be referred, it will be referred as a C series or R series, depending on the number of claimants and respondent. Conduct of hearings and cost, whether it will be virtual hearing or physical hearing, how the cost will be shared, whether it will be shared half and half, or if there are more respondents, the proportion of sharing the cost. Communication between the parties, again, it should not be ex parte communication between the party and the tribunal. If there is a communication, all parties should be marked on that. And any other practice direction in terms of the timelines and other administrative issues can be mentioned in PO1. Preliminary case assessment is very important for any international commercial arbitration. When we start any international commercial arbitration, we should understand the underlying structure of the commercial relationship between the parties. It can be as an arbitrator or as a counsel. Whenever we come across any international arbitration, the commercial relationship matters a lot. We have to also see the choice of law, choice of language, and seat of arbitration. Because unless we have clarity on the choice of law, governing law of the contract, the language and the seat, a lot of issues get decided and they fall in place. Determine the questions of jurisdiction and whether there is a need to seek interim relief. The jurisdictional issues should be raised at the earliest to preserve them. And also interim relief has to be sought in time, because once the subject matter of arbitration is not protected, it becomes very difficult to then enforce the award, because an award will be a paper award which may not have any effect of real enforcement. The parties and the tribunal also should chalk out the issues beforehand to avoid multiplicity of proceedings. The issues should be framed so that the parties know exactly what are the issues between the parties, and dispute can be then decided around those issues. For the claim with low value of little chances of success, parties and the arbitral tribunal should encourage mediation or other form of ADR. The parties can also have multi-tiered dispute resolution clauses in their contract, so that whatever they can decide or settle by way of a mediation can then not be referred to arbitration. The arbitration and mediation can also go hand in hand, while in a hybrid form, where you start with the mediation, try to resolve the dispute in mediation, and whatever is not resolved, you can go to arbitration and then come back to mediation. And vice versa, med also, there you start with arbitration and go to mediation and come back to arbitration. In the early case management pre-hearing preparations, for the early case management conference, the procedural conference is necessary to identify the issues and procedural steps necessary to resolve the case. In this, it is encouraged that the client representatives are also present, so that they can explore the possibility of settlement, because if the tribunal feels that the dispute can be resolved by way of amicable discussion or mediation, then the parties should try for that. All the stakeholders, including the witnesses, experts, should be kept in loop in terms of the timelines, because if they are not available, then those dates should be avoided in the timetable for the proceedings. And once the timetable is fixed, there should be a strict compliance of the timetable by the tribunal as well as the parties. And because it is important to have a short and realistic time period, we should not give very long period for completion of pleading or any procedural step, or it should not be very short also, where every time the party comes and seeks extension of time. Use of infrastructure and information technology again helps a lot in case management issues. Filing of electronic documents, scanned copy by way of a secured link, or video or audio conferences for procedural hearings are norms now, rather than the exception. It's a new normal to have most of the hearings as a virtual hearings to save time and cost. When we talk of bifurcation, bifurcation is the issue that may arise early in an arbitration, is to whether to bifurcate the jurisdiction and liability from the quantum that is a liability to pay damages. If there is a concern whether the tribunal has jurisdiction to hear all or part of the claim, the parties may choose to bifurcate the proceedings and the tribunal to make an initial decision as to whether it has the jurisdiction. Because if there is no jurisdiction, there is no point going into the merits hearing and trying to waste time and cost in the arbitration. So therefore, it is important that bifurcation is requested and the tribunal considers the request for bifurcation when it comes to the jurisdictional challenges. Bifurcation is provided for in some but not all major institutional arbitration rules used by commercial and state parties. However, when the bifurcation is addressed in institutional rules, it is set out in a general concept to be used by the tribunal as it deems appropriate. So these rules are only providing some kind of framework, but it does not provide exact instances where the bifurcation can be there. For example, in ICC, in Appendix 4, Paragraph A, provides that the tribunal may bifurcate the proceedings or issue partial award when doing so may genuinely be expected to result in a more efficient resolution of the case. Now, this is left to the tribunal to decide what is more efficient resolution, and the discretion is given to the tribunal. In LCIA rules also, Article 14.64 provides that the tribunal may determine the stage of the arbitration at which any issue or issue shall be determined and in what order. Again, this gives an indication that the tribunal has complete freedom to decide the order of determining the issues and which one will be decided as the preliminary issue. While our Arbitration Act in India does not expressly provide for bifurcation, it provides that the arbitral tribunal may, during the arbitral proceedings, make an interim arbitral award on any matter with respect to which it may make a final award. Thus, even the Arbitration Act envisages that the arbitral proceedings may be bifurcated and adjudicated in phases. So there is a partial award or an interim arbitral award. This is different from an interim measures. This is an award. Award is final and binding on the parties. Sometimes emergency arbitrators call their interim measures as an emergency award, but again, it is not an award because it does not determine anything finally. The definition of award is that it has to determine the rights and obligations of the parties finally. And once an award is passed, the time for challenging the award starts from that date. So even if it's a partial award, the parties have to challenge that award if they are not happy with it, rather than waiting for the final award. The final award can be passed in many arbitration. We have seen that the first award is on the liability, which is a partial award, and the second award, which is a final award, is on the quantum of the liability. The time and cost spent on a case can be reduced significantly if the party is successful in having all the claim dismissed at the jurisdictional space, and the arbitration is likely to be significantly longer if the claims go ahead, notwithstanding the bifurcation. A review of arbitration cases carried out by the ICSID also shows that the bifurcated proceedings that lead to an award on merits take almost 2 years longer than the average time for a blended hearing. The parties should be careful in properly considering whether bifurcation has a significant likelihood of leading to either of the dismissal of all or majority of the claim, or may increase the likelihood of early settlement prior to issuing a request of bifurcation. So bifurcation request should not be issued mechanically. There has to be clear issues which can be decided at the first instance. Then and then only the bifurcation should be requested. In the event that the party requests that the damages are assessed prior to the merits, the parties and the tribunal must take due care to ensure that the damages can be properly separated from the merits argument, and that an award concerning the damages does not require any prejudgment of the merits. So the tribunal has to be very careful. In one case, we had a warehousing contract where the whole issue was that the invoices were running into thousands of pages. First, we said that told the tribunal that first let's just decide whether we are liable to pay any amount for excess storage. And if yes, then only we will go into the quantum phase. And it worked out very well because we won at the first instance. There was no need to go into the quantification stage. So that way we save a lot of time and cost in the entire arbitration, provided that is possible to be bifurcation. In this, as I gave example, the split between damages and liability may be more complicated between jurisdiction and liability. And there is a risk that the work will be duplicated and the cost can be increased through the bifurcation. So the other way to look at it is that you will have to lead evidence twice over and make final hearing twice. So if you are not successful, then the second phase can be slightly more expensive because it adds or overlaps with some of the arguments which are already made for the first phase. So the bifurcation may promote early settlement if one party realizes that it's not succeed in all claims and wishes to compromise. In ICC case of Brazil versus YPF, the bifurcation of liability and damages was granted, and the arbitral tribunal ultimately held YPF liable. The only outstanding question was the measure of YPF exposure, that is the quantification of damages. And this allowed the parties to negotiate a settlement without preparing protracted submission on determination of damages. So sometimes bifurcation can also lead to early settlement between the parties. Now coming to the document production. The document production is very important phase of an arbitration. As with the most aspect of arbitration, the document production is also agreed by the parties. If the parties are not agreeable, then the procedural order number 1 will determine the manner in which the document production will be decided by the tribunal. The requirement and procedure for production of documents are best addressed as the case management conference, where the parties and arbitrators with common law background are familiar with discovery process, and they're likely to provide for more extensive document production than parties and arbitrators with a civil law background. The party seeking documents to prove its case will argue for more extensive document production than its opponent, who would prefer less production and let the documents remain off the record. So there are always tensions between the parties. Then the parties have to decide and come to a common ground with regard to the process which will be followed for discovery and production of the document. The production phase of an arbitration is very important to the assessment of the damages, as the financial information is rarely disclosed to the opposing party prior to the arbitration. The lack of full and clear information can lead to either inflated or underestimated damages claims, which could be solved by early disclosure of the relevant information and cooperation between the parties. We have seen that document production can lead to a lot of conflict in terms of the time and cost being spent by the parties, because if the tribunal allows extensive discovery of the document, that can also impact the merits of the case and also increase the cost, because the party has not only to search for those documents and also produce it, which can be then used against that particular party. The easiest way is to adopt the soft law, which is the IBA rules. Now, IBA rules on taking evidence in international commercial arbitrations are very helpful to decide how to do the production because it has a detailed step-by-step process to disclose the documents. And they have the even protection inbuilt to protect the commercially sensitive documents or having to maintain confidentiality. As per Article 9 of the IBA rules, the tribunal may either of its own volition or at the request of the party exclude any document, statement, oral testimony, or inspection on the grounds of commercial or technical confidentiality that it deems compelling. Many times, this commercial confidentiality or a client attorney privilege are also sometimes the grounds of discussion before the tribunal in international commercial arbitration, because many times the disclosure itself can win or lose the case for some parties. In the absence of specific provision for dealing with the disclosure of discovery of the documents in the Arbitration Act, many times arbitral tribunal fall back on the CPC. Although CPC in India is not strictly applicable to the arbitration proceedings, we have seen that the arbitrators who are coming from the judicial background, who have been as part of the judiciary, or they are former judges of High Court and Supreme Court, they follow this process of admission denial of documents and also try to have the document production in which is there in the CPC. Whereas in international commercial arbitration, reference schedule is very famous, which has 4 columns where the document is requested, the reason for that request is given, and then the opposition by the other side is given in the 3rd column, and the 4th column is the decision by the tribunal. Actually speaking, there is no single approach which will constitute the right balance of the document production in international arbitrations. However, the arbitrators are duty bound to look at the document production not only from the legal point of view, but also from a point of view of business efficacy. Sometimes the documents are sought in a fishing and roving inquiry to cause damage to the other side, or they are not necessary for determining the real controversy between the parties. E-discovery is also a developing trend in a complex commercial arbitration because most of the documents are stored electronically. And when the parties seek significant discovery from the other side, e-discovery tools are very important, which have the search words, and there are agencies they provide for such kind of services. Arbitral tribunal has the discretion to make determination pertaining to the admissibility, relevance, materiality, and weight of any documentary evidence. If there is any objection to production of documents, it has to be given in writing to the arbitral tribunal, and the ground of objection could include lack of relevance, legal impediment, unreasonable burden to produce, commercial and technical confidentiality. If the parties are failed to resolve the objection, the tribunal may order production if it is found that the documents are relevant to the case and none of the reasons of the objections apply. And failure to produce evidence has a bearing on the assignment of the cost of the arbitration, and the arbitral tribunal can also draw an adverse inference if the party is not producing the document despite being in power and possession of the party after the direction of the party of the tribunal to produce the documents. So this is a very important aspect of the arbitration. It has to be done very carefully. We have seen in practice many of the arbitrations get settled at the discovery stage itself, because once the request for discovery or the direction for discovery comes from the tribunal, the parties know that these documents are damaging and going against them. In one of the cases, the parties had an issue with regard to the joint measurement of the property. And there was a joint measurement done. And after that, there was an internal email which was sent by one of the officials who attended the joint measurement to its own management. And that was suppressed from the tribunal. And after that person left the organization, he produced that document. And that completely changed the entire argument of the parties with regard to their position. Contemporaneous evidence has to be there. So if we define or make the request in a careful way, it can be an immensely helpful tool to seek to force the other party to produce documents during the arbitration proceedings. Now, let us discuss very briefly the concept of emergency arbitration in international perspective. The concept of emergency arbitrator has evolved along with the institutional arbitration. The idea is to provide urgent conservatory measures or interim measures before constitution of the regular tribunal. If the party is not able to wait for the formation of the arbitral tribunal, the arbitral institution will appoint the emergency arbitrator within 2 days, and the emergency arbitrator has to pass the order within 14 days. Now, emergency arbitrator ceases to have any jurisdiction after he or she passes the interim order. And the nature of interim orders include asset freezing orders, prohibitive and mandatory injunction, orders for the preservation and inspection of the evidence, etc. In one of the cases of emergency arbitrations we did, there was a request made for mandatory injunction to vote in a meeting of the board of directors of the company in a particular way to allow borrowing of the funds from the financial institutions. Because the ground which we had taken is that if the borrowing is not achieved within a time, the company may come to standstill. And the tribunal granted mandatory injunction to direct one of the parties to vote in favor of borrowing from the financial institutions. The interim measures to obtain orders or interim orders to prevent the other party from dissipating evidence or assets is also very important. And the emergency arbitrator has powers to pass all kind of interim relief which the regular tribunal can pass. Such appointment does not preclude a party to approach the competent judicial authority for interim measures. So if you have an emergency arbitration, we have a choice between the national court to grant interim relief or to go to emergency arbitration. But of course, emergency arbitrator has the same power to grant the interim relief as the courts. The only question comes of the enforceability, which we will just discuss. The emergency arbitrator has also power to decide its own jurisdiction, check the veracity of the claim party seeking such appointment. The emergency arbitrator cannot pass an ex parte interim relief. The parties have to be given notice and an opportunity of hearing or filing a written submissions. The emergency arbitrator has the wide discretion to award emergency measures and the grant relief that it deems necessary to preserve the evidence and the status quo. Some powers that fully constituted tribunal would have are also given to the emergency arbitrators. LCI rules, HKIC rules also make specific provision to provide the same powers as the regular tribunal to the emergency arbitrator. What are the standards applicable to grant of emergency relief? It is the same as grant of relief by any court or regular tribunal. First is whether there is a prima facie jurisdiction, whether the applicant has made a prima facie case on the merits and has a chances of success before the regular tribunal, and whether the urgency justifies the requested relief. This is very important because you are going into emergency arbitration. It has to be shown that it is urgent and it cannot await the constitution of the tribunal. Whether there is a risk of irreparable harm and request if the request is denied, and proportionality, that is whether the harm avoided is greater than the harm that the respondent would potentially suffer as a result of emergency measure. So the tribunal or the emergency arbitrator has to decide the balance of convenience and see that who will suffer more loss if the emergency relief is granted or not granted. The standard applied by emergency arbitrators are broadly similar to those applied by the court in examining the application under Section 9 of the Arbitration Act or Section 17 of the Arbitration Act. But the two additional grounds are to be that the existence of an urgency or emergency which cannot await the constitution of the tribunal and the prima facie jurisdiction of the emergency arbitrator are in addition to those general rules. Now, let us see what are these rules of various institutions. So one thing is clear is that the emergency arbitrator can be appointed only by the arbitral institutions. So in ad hoc arbitration, the parties don't have an advantage of going to emergency arbitration. They have to go before the constitution of the tribunal. In all Indian institutions, we have now the provision of emergency arbitration. In Delhi International Arbitration Rules, Article 29.1 provides, Article Rule 18.18A1 provides for emergency arbitration. ICC rules Article 29.1, MCIA Rule 14.1, SIC also, as well as Nani Palkiwala and LCIA rules provide for emergency arbitrations. The arbitral tribunal, once it is constituted, has power to either confirm, reconsider or modify, or terminate or vacate or revoke or annul the order made by the emergency arbitrator. All these rules provide for the same. Seeking measures from the judicial authority, again, parallelly, it is provided, but Delhi High Court decided in a recent case that once you go to emergency arbitrator and has been unsuccessful, you cannot come to then court and ask for the same relief. Because once you make an election between the court and emergency arbitration, then the party is bound by that selection and cannot then have two bites at the apple in the same cause of action. Appointment of an emergency arbitrator is either done between 1 day to 3 days. Most of the institutions provide 1 day, 1 business day, or 2 days, or maximum 3 days. So it is very, very quick. Irrespective of the weekends, we have seen the emergency arbitrators getting appointed. As far as the time limit for passing of the order is concerned, DISC provides 7 days, whereas ICC provides 14, whereas rest all it provides for 14 days. NPSC does not provide the outer limit, but within 2 business days of the appointment, the arbitrator has to establish a schedule for consideration of the application. As far as fees is concerned, it's a fixed fees. So various arbitral institutions provide for the fees of the emergency arbitrators. DISC has 25,000 rupees, ICC has $40,000, LCIA has 9,000 as the application fee and 22,000 as the arbitrator's fees. So various rules provide for administrative as well as arbitrators' fees for deciding the emergency arbitration reliefs. As far as statistics are concerned, in 2020, LCIA had around more than 400 cases as compared to ICC and HKIC, which had around above 800 and 1,000 cases. Emergency arbitration applications out of this, where LCIA, ICC had the maximum numbers, and HKIC and LCIA was followed after the CR. So the total number of cases and emergency arbitration you see gives the total way in the number of emergency arbitrations invoked in each arbitration is available from these statistics. As far as India is concerned, the case of Amazon versus Future determines the enforceability of the emergency arbitrators orders, because in India, we tried amending the act to include the emergency arbitrator in the definition of the arbitral tribunal, both in 2015 and 19 amendments. But what we could not achieve by way of an amendment, the Supreme Court has clarified that if the arbitration is seated in India, then there is no need to go for another Section 9 to enforce the orders passed by the emergency arbitrator. And because the emergency arbitrator is recognized in the arbitral institutions rules, the order passed by the emergency arbitrator would be enforceable as if it's a decree, it's the order passed by the court under Section 17(2) of the Arbitration Act. So emergency arbitrators orders are put at par with the orders passed by the regular tribunal under Section 17 of the Arbitration Act. Now let us also talk about the enforcement of international awards. The international awards are basically foreign awards. The enforcement of award in India-seated international commercial arbitration is governed by Section 36 of the Arbitration Act, which is in Part 1, which provides for enforcement of an awards arising out of India-seated arbitration in terms of the Code of Civil Procedure, and it is deemed to be a decree passed by the Indian court. The amended Section 36 after 2015 clarifies that there is no automatic stay on the award once it is challenged under Section 34. Earlier there was an ambiguity in the language of 34, which says during the pendency of 34, the time for filing the enforcement would not start. But now, after the 3 months time period for challenging the award with the 30-day extension, which is maximum permissible under Section 34, the arbitral award can be enforced under Section 36 as if it's a decree of the court, unless there is a stay granted by the court under Section 34 by making a separate application under Section 36(2). This is again a provision which is a welcome provision by way of amendment, that many of the frivolous challenges have reduced. And also, whenever the stay is granted, the provision provides for deposit of the amount which is awarded by the arbitral tribunal if it is a money award. So many times we have seen that 100% amount which is awarded by the tribunal has also been deposited by the parties as per the direction of the court. The question arises, what is the proper court for enforcement for international commercial arbitrations seated in India? It would be the commercial division of the High Court, where the assets of the opposite parties are situated. And if the subject matter is not money, where the commercial division of the High Court, where the opposite parties resides or carries on business or personally works for gain. So if there is an Indian party where the assets are located in India, or the party is carrying on business in terms of a non-money award, it will go to the High Court having jurisdiction over that location. In Sundaram Finance versus Abdul Shamid, the Supreme Court held that an enforcement of an award through its execution can be filed anywhere in the country where such decree can be executed, and there is no requirement for obtaining a transfer of the decree from the court, which would have the jurisdiction over the arbitral proceedings. So if the arbitration proceedings are seated in Delhi and the assets are located in Kolkata, there is no need to go to Delhi court and ask for transfer of the award from Delhi to Kolkata. As per this judgment, the party can straight away go where the assets are located and not where the seat of arbitration is there. As far as foreign awards are concerned, there are provisions in Part 2 of our Arbitration and Conciliation Act. Section 44 defines the foreign award, which is an award made outside India, territory of India, which is a reciprocating territory by India. Section 46 provides that the award is an enforceable foreign award, is a binding on the persons who are parties to these awards, and such persons may also rely on the award by a defense setup or otherwise in legal proceedings in India. Section 48 provides for grounds under which the enforcement of an award can be refused, that is for resisting the enforcement. These are the grounds which are provided, and Section 49 says once the court is satisfied that the award is enforceable, the award shall be a deemed decree of an Indian court. So it is, even though the award is passed outside India as per New York Convention, and India is a signatory to New York Convention, and if it is ratified, if the territory is ratified by India, who is also a signatory of New York Convention, then the award will be treated as a decree of Indian court and then enforced under Order 21 of Code of Civil Procedure applicable in India. Now, the definition of foreign award is provided in Section 44. It says it has to be on an arbitration arising out of a differences of a commercial legal relationship under Indian law. It has to be made after the New York Convention has come into effect and pursuant to an agreement in writing which the New York Convention or Geneva Convention apply, and in a territory notified by central government as a reciprocating territory. There are currently 46 countries who are signatory to the New York Convention and also ratified by India as a reciprocating territory. Now, to oppose an enforcement of a foreign award under the New York Convention, the enforcement may be refused only if the requesting party furnishes the court that the parties had some incapacity, or they had no valid notice, or the agreement itself was not valid under the governing law or the law of the seat of the arbitration. The arbitral tribunal exceeded the jurisdiction, the composition was not as per the agreement between the parties, or the award had not become binding at the law of the seat of the arbitration. Additional grounds are that the subject matter of the difference is not arbitrable, or it is against the public policy of India. So now the Arbitration Act under Section 48 provides very limited grounds for resisting the enforcement. In 2015 amendment has also has streamlined the enforcement process by introducing the explanation to the uh, concept of public policy. And what we have done is that after this amendment, we have narrowed down the definition of public policy for both challenging the arbitration award and also resisting the enforcement of the foreign award. The definition of public policy again was examined in the recent case of Sangyong, where the expression public policy of India, whether contained in section 34 or 48, would now mean only the fundamental policy of Indian law. And fundamental policy of Indian law would be relegated to the original definition of Renu Sagar, which was the original narrow definition of Renu Sagar under 1940 Act, would then now be applicable to this concept of public policy. So the court cannot go behind the award, foreign award. Once the foreign award is passed, it is mandatory that the court enforces unless it checks the conscience of the court and it is so patently illegal that it is against the fundamental policy of Indian law. Therefore, the provision or the law laid down by the Supreme Court in ONGC versus Saw Pipes and ONGC versus Western Geco is no longer available. And therefore, you cannot interfere with the award by refusing to enforce the award for not having a judicial approach after 2015 amendment. In Tejas Karia, this was further explained, and it was the Renu Sagar case was relied upon at a great extent, and the public policy exception to the enforcement of foreign award is treated to be very narrow ground, and only egregious circumstances such as corruption, bribery, or fraud would constitute violation of most basic notions of morality and justice. If the foreign award fails to determine a material issue or fails to decide a claim or a counterclaim in its entirety, the award may shock the conscience of the court and may be set aside. However, if read as a whole, if the award addresses the basic issues raised by the parties in substance and decides the claims and counterclaims by the party, enforcement must follow. The convention of the provision of the enactment is not synonymous to the contravention of the fundamental policy of law or of a jurisdiction. For example, where a subject matter of a difference is not capable of settlement by arbitration under laws of India, then it is not arbitrable. The court will not enforce the foreign award. The Tejas Karia also laid down the grounds relating to patent illegality on the face of the awards are outside the scope of interference in the international commercial arbitration, and the foreign awards cannot be refused enforcement on the ground of patent illegality. The ground of resisting enforcement of foreign awards may be classified into three groups: the grounds which affect the jurisdiction of the arbitration proceedings, the grounds which affect the party interest alone, and the grounds which go to the public policy of India. Where the very jurisdiction of the tribunal is questioned, there can be no discretion in refusing the enforcement. In Government of India versus Vedanta, under the Arbitration Act, it was held that there is no requirement for a foreign award to be filed before the seat court and obtain a decree thereon, and after which it becomes enforceable as the foreign decree. A party may apply for recognition and enforcement of a foreign award after it is passed by the arbitral tribunal, and the application is not required to obtain a leave from the court at the seat or under the laws of India in which the award is made. So if the seat of arbitration is Singapore, you don't have to go to Singapore court for enforcement. If the assets are located in India, it is an international award and it can be enforced straight away in India. We can file multiple enforcement also in different jurisdictions. In many cases, we file enforcement in US or Europe and in India at the same time, if there are assets available outside India as well. The enforcement of an award is a subsequent and distinct proceedings from setting aside proceedings at the seat. So if the award is getting set aside at the seat, that also can have a consequence on the enforcement. But in many cases, the courts have also taken a view that even though the award is set aside at the seat, that will not preclude the enforcement outside in the other jurisdiction. because the words used are may, that if the award may be not binding at the seat, and therefore if the setting aside of the award will not come in the way of enforcement of award outside India. But in India, we don't have that clarity. There was one case where we were appearing of Betamax, where the enforcement of the proceedings were in India, but the award was set aside in Mauritius, which was a seat, and the court said that once the award is set aside, they cannot grant any interim relief in aid of the enforcement in India. The court before which the foreign award is brought for recognition and enforcement would exercise secondary or enforcement jurisdiction over the award to determine, and has no power to set aside the award. It can only either grant the enforcement or refuse the enforcement. In many cases, we have seen that I argued a case where the question came up is that the appeal provided under the enforcement, there is under section 50, is only one-way appeal, as to only the appeal is against the refusal to enforce an award and not against the order granting the enforcement. And the question came up is that whether the arbitration agreement will prevail or the commercial court will prevail, because a commercial court act provides for appeal against any order, whereas the Arbitration Act under Section 50 provides appeal against only the order refusing to grant enforcement and not against the order granting the enforcement. And the court held that the Arbitration Act will prevail because it's a specialized legislation. It is a complete code, and therefore the Arbitration Act will have a power to decide whether appeal is maintainable or not. And therefore, in the case of OCI Corporation versus Kandla Exports, the court said that the Commercial Court Act will not have an implication where the Arbitration Act prohibits any appeal against an order granting the enforcement of the award. Now, let us come to the last topic for today for my presentation, the international commercial arbitration in the COVID situation or the post-COVID situation. When COVID started, all the arbitral institutions were quick enough to have a response to the COVID situation. Certain arbitration institutions like ICC, SIAC, LCIA came up with the protocol, and they came up with a joint statement in April 2020, declaring that it was their joint ambition to support stability and foreseeability in a highly unstable environment, including by ensuring that the pending cases may continue and the parties may have their cases heard without undue delay. The arbitration institutions also adopted for the exceptional circumstances by using technology. And the technology has come to a rescue of all of us. Otherwise, for last 2 years, we all lawyers and the arbitrators would have been without any work. The way we could survive is only on the basis of these virtual platforms that we are using right now to have the arbitration hearings. And I have conducted a number of hearings for full day hearings, including evidentiary hearings before the arbitral tribunals without any difficulties. Of course, there are pros and cons of virtual hearings. You don't have that connect. There is also a possibility that the parties may misuse the technology to suit their requirements. But more and more use of technology will standardize this all difficulties, and we can see that technology can bring a lot of value on table by reducing the time and cost. All these institutions promoted the adoption of electronic case management tools. So we have now filing of all the pleadings online, and you can access it also online. The inclination of the arbitral tribunal and parties to convene full virtual hearings, and also promulgation of merit protocols and guidelines relevant to this novel procedures. Now it is a new norm that the international commercial arbitration has adopted is of virtual hearing. And as far as possible, the parties and the tribunals try to conduct the arbitration proceedings virtually. Most rules provide now for virtual hearings. The Arbitration Act is not providing any procedure for virtual hearings, but also it allows the tribunal to decide the procedure under Section 19, and that includes that the tribunal has discretion to even direct the virtual hearing. The arbitral tribunal can direct the parties to the arbitration proceedings to file pleadings through email and conduct proceedings through the means of video conferencing, aiding the social distancing with minimalistic loss and productivity. Of course, now after COVID is not that serious, we are still continuing to have the virtual hearing for at least procedural hearings and sometimes also for the final hearings. Evidentiary hearings, parties are of the view that it is better to have physical hearing if it is possible when the witness cross-examination has to take place. The advantage of virtual hearing is that it significantly reduces the time and cost and the travel across the globe. It especially gives incentives where the physical hearings are not required. This also have an environmental benefit since there is no carbon footprint of travel, and it requires the parties to be wherever they are and effectively represent their case in international commercial arbitration. There are many case management systems which has evolved during the COVID system and which we are still using. It was all in pipeline, but COVID kind of accelerated the whole process of digitization and use of electronic case management systems. In electronic case management systems, all the documents in particular are submitted on a single platform, and the parties file their submissions and exhibit all of documents also on the platform. The tribunal and the institutions would communicate with the parties exclusively through that platform, and complete record of the case would be stored at one place. So there is no difficulty in terms of confidentiality because it's all secured place and only the access is given to the users with secured passwords. The hard copy of the file could be completely avoided, and as could be there can be a need for bundle of hearings. Everything can be online, and there is no need to print the bundles, hearing bundles. Parties can refer to online documents, which is very easy. Now we have softwares which also allow the parties to navigate through the complex and voluminous documents. Third-party funding has also evolved during the COVID. Due to COVID disruptions, the parties' financial ability to pay external counsel has reduced. The third-party funding has emerged as a solution for that because the third-party funding also brings in discipline and quality in terms of representation, because they are interested in maximizing their investments. If there is a funder involved, the funder would like to have their own lawyers or the counsels to review the case before funding the claimant. The concept of third-party funding essentially means that an unrelated, non-beneficiary third party funds the arbitration proceedings in exchange of a profit once if the claimant is able to recover any money from the award passed by the arbitral tribunal. COVID-19 has spurred a spike in the third-party funding applications from the corporate looking to increase their liquidity while pursuing the legal claims. Because although you pay a premium once you win to the third-party funder for funding through, that's the return on their investment. But at the same time, it frees up the liquidity crunch, and that money can be used, put into the business, which is more profitable. In India, there is no prohibition against third-party funding, but it's not recognized also because we have the concept of maintenance and champerty where the lawyers cannot fund the litigation. But if there is an unconnected third party who is not a lawyer of the party, then or the advocate can definitely provide the third-party services. And the Supreme Court has observed in A.K. Balaji case that there is no restriction on third-party funding litigation and getting repaid after the outcome of the litigation. Of course, it cannot be a success-based fees for the lawyers, but it can be an arrangement for third-party funding. So I would be happy to answer if you have any questions. We have a couple of minutes left for the questions. And if you have any questions, you can put it on the chat box or you can ask directly on the screen. Thank you.
Any questions from anybody? So I think you were very, very clear. It was a wonderful session, sir. So I don't think there are any questions.
Thank you. Thank you. No, this is all straightforward topics. So maybe they got the answers during the presentation only. So I'm sure
Yes, sir.
there won't be any questions.
Even your slides, sir, they were very detailed. All the case briefs as well, sir.
Sure. If parties are interested, we can participants are interested, we can share the slides also with them. There is no difficulty.
Sure, sir. Thank you, sir, for sharing your experience and enlightening the participants with your knowledge on the topic. We're really grateful to you for taking out time of your busy schedule to join us for today's masterclass. Thank you, sir. There will be a feedback form shared in the comments box in the sessions after lunch break. It is mandatory for all the participants to fill the form, as we will only be providing certificates to those who have filled the feedback form. Now we will be taking a 30 minutes lunch break before we reconvene for our next session with Ratan Singh, sir. Thank you, sir. Thank you for your time.
Thank you. Pleasure. Bye.